Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals for the Fourth Circuit. This is United States of America versus Marcus Taylor and Daniel Hurls. In this case, the United States of America brought criminal RICO charges against several members of the Baltimore Police Department. These several members of the Baltimore Police Department engaged in ongoing criminal conspiracy to deprive people of money by raiding money from people's homes and taking it and keeping it for themselves privately. So we're going to read this case where they appeal their sentence of this ongoing RICO case in the Baltimore Police Department. So let's get started with this. In February 2017, a federal grand jury indicted 7 officers of the Baltimore City Police Department for their participation in a racketeering conspiracy and substantive acts of racketeering in violation of the Racketeer Influenced and Corruption Officials Organizations Act, otherwise known as RICO. The officers, who were members of the police department's gun trace task force, were charged with robbing citizens during the course of their police service, taking money, jewelry, and other items. They were also charged with committing fraud in order to obtain overtime pay from the police department. 4 police officers pleaded guilty and cooperated. 1 officer pleaded guilty but did not testify. And 2, Marcus Taylor and Daniel Hurls, the appellants, went to trial and were convicted of RICO conspiracy in violation of 18 U.S.C. 1962, substantive acts of RICO in violation of 18 U.S.C. 1962, and Hobbs Act robbery in violation of 18 U.S.C. 1951. The district court sentenced each of the officers to 216 months of imprisonment. So we see what's going on here. The police department in these people, these 7 officers at least, engaged in conspiracy to take money relating to drug seizures or other seizures for themselves, and they were sentenced to 216 months in jail, which is roughly 18 years. So, yeah, they're appealing their criminal charge for their convictions. Taylor and Hurls contend that their evidence was insufficient to convict them. In particular, they contend that the evidence failed to show they had committed the wire fraud, one of the predicates for the RICO count, in that no evidence was introduced at trial to show they could have foreseen that the paper slips the officers used to fraudulently claim overtime pay would cause a transmission by wire in interstate commerce. And the evidence failed to show that they had committed acts constituting the Hobbs Act robbery or robbery under Maryland law, another alleged predicate for the violations. For the following reasons, we affirm. Sorry, no. Thank you for playing. Please enjoy your time in jail. Count 1 charged the defendants with RICO conspiracy, alleging that the Baltimore City Police Department was the enterprise. So I just want to take note at how bold that statement is. In RICO, you need an enterprise, a corrupt enterprise. What is the corrupt enterprise according to the United States government? The corrupt enterprise is the Baltimore City Police Department. That's where we are. Wow. Through which the defendants engaged in a racketeering conspiracy, whose predicate offices included wire fraud, attempted robbery, conspiracy to commit robbery, extortion, attempted extortion, and conspiracy to commit extortion in violation of law, and controlled substances offenses. Count 2 charged the defendants with 22 predicate acts, each identified by a date and a victim. So nice, we did it 22 times. Yeah, great. Count 3 charged them with alleged robbery of Uri Stevenson in violation of law. Count 4 charged them with possession of a firearm in furtherance of the crime of violence. So those firearm enhancement charges that get so many criminal defendants finally come back to bite the police. I wonder how many people the police put in jail who were charged here specifically, how many people they put in jail and with a sentencing enhancement for using a firearm in furtherance of the crime. And now they are getting sentenced for using a firearm in furtherance of the crime. The firearm being the one that was issued by their department because they're police officers. So I just enjoy that little bit of irony that, this is coming back to bite them when I'm sure they've used it many, many times against others. Count 3 charged them with Hobbs Act robbery for robbery of Ronald and Nancy Hamilton. And count 6 charged them with possession of the firearm. The government presented testimony from over a dozen witnesses, including 4 former officers who had pleaded guilty and agreed to cooperate. The former officers all testified that during their time in the gun tracing task force and for some time prior to the assignment on the special enforcement, they conducted illegal searches and stole money, drugs, and other items while acting in law enforcement capacity. So this whole thing has turned into one massive episode of The Shield. The show was not designed as a how-to guide. More particularly, the government presented evidence to show the officers, including Taylor, targeted a drug dealer as he was in a minivan selling cocaine to Demaritus Brown. In searching the vehicles, the officers found cocaine and a backpack containing money. Stevenson testified at trial that, while he had not counted the money, he expected the bag to contain approximately $21,500 from Brown as a payment for the cocaine. He explained that he knew Brown and that Brown always brought the correct amount of money. It's nice when you can testify to how much money is in the bag from the drug deals because of other drug deals with this person, and you know that they always pay the amount due. So that's just a nice little touch. But after Taylor seized the money from the vehicle, he brought only $15,000. $15,000 seems less than $21,500. I wonder what happened to the difference. And the $15,000 was submitted as evidence. After the stop and seizure, the GTTF officers went to Stevenson's house and did what they called a sneak and peek, which involves going into someone's house with anyone knowing, sneaking around, and taking a peek and searching throughout the house without a warrant. Okay, sneak and peek search warrants are a thing. Sneak and peek, because I feel like it, is most decidedly not a thing. During the search, they uncovered cocaine and a safe. Some officers then left to obtain a search warrant. Upon returning with the warrant, officers pried open the safe and found $200,000. After taking $100,000 for themselves, they reported that only $100,000 had been found in the safe. They then split the $100,000 amongst themselves. Good work if you could get it, I guess. The GTTF officers, including Herschel, targeted Ronald Hamilton, who they believed to be a big-time drug dealer, stopped him, and after he acknowledged about having $40,000 in his house, drove to his house and entered it without a warrant. Again, you can't do that. You have to get a warrant. It's in the Fourth Amendment. I've read it. As a result of the search of his house, the officers uncovered some $70,000. Of that, they took $20,000, leaving $50,000 to be discovered by the Maryland State Police to legitimize the encounter. These officers then split the $20,000 amongst themselves. With respect to the overtime fraud, the government presented evidence defendants regularly submitted overtime slips on their own behalf and on behalf of others for hours they had not worked. Using a computer, the timekeeper entered the information into a timekeeping service, the third-party company that the police department had hired to process the data. The FBI testified that Sergeant Jenkins, Leroy Jenkins, would authorize the officers' overtime offers by signing them off and turning them into the system. After the data was received by the ADP in South Dakota, the officers were ultimately paid by either check or, in most cases, by direct electronic depositure into their bank accounts. Cage Run asked, why didn't they do civil asset forfeiture? See, the problem with civil asset forfeiture is that the government gets to keep all the money. So they had done a civil asset forfeiture, the police department would get to keep the money. But the police department would get to keep the money. This way, they get to keep the money personally, privately. That's why they didn't do civil asset forfeiture, because they wanted it for themselves. It's only okay to steal if the government is doing it. That's the civil asset forfeiture lesson. But if you're doing it as an individual, that's a no-no. The jury found them guilty of the conspiracy, but it acquitted them of possession of the firearm charges. That's very sad. The district court sentenced them to 216 months imprisonment on each count to be served concurrently, which was near the low end of the guidelines. So the 18 years they got was actually a break from the court. So, okay, I guess everyone's entitled to a break now and then, so 216 months for you is what the court said. Taylor and Herschel contend that their convictions for count 1 should be reversed because the government failed to provide a pattern of racketeering activity, which may be shown by at least 2 acts, by presenting insufficient evidence in support of the necessary charges of one found by the jury. Well, we want to overturn a jury verdict based on insufficient evidence. As you might expect, that's going to be pretty difficult. So let's see what happens. To convict the defendants, as charged, the government was required to prove the existence of the enterprise. As the indictment charged and the jury found, the police department was the enterprise through which the officers acted to enrich themselves by committing the act. What is the enterprise? The police department. Does it exist? Yes. How do we know? The jury said so. Excellent. The wire fraud statute provides that whoever, having devised or intending to devise any scheme or artifice to defraud, transmits or caused to be transmitted by means of a wire, communication, interstate or foreign commerce, any writing, sign, signal, picture, or sounds for the purpose of executing such a scheme or artifice shall be punished. Thus, to establish a violation of the statute, the government must prove the existence of the scheme to defraud and the fact the defendant used or caused the wire communication in furtherance of the scheme. And the district court instructed the jury it's not necessary for the defendant to be directly or personally involved with the wire communication as long as that communication was reasonably foreseeable in the execution or carrying out of the alleged scheme to defraud in which they participated. So as the court is pointing out quite correctly, it's you did it or caused it to be done. And it doesn't require you to do anything in particular. It only requires you to take such actions as will be reasonably foreseeable to cause it to do. So if by your actions, somewhere down the line, you cause it to communicate on wire and it was reasonably foreseeable, good enough. You've participated in a scheme that caused it to be transmitted. Okay, noted. The evidence shows defendants and their co-conspirators submitted fraudulent paper time slips on their own behalf and behalf of others in the conspiracy, claiming they worked overtime hours for hours they had not worked. These slips were submitted to co-conspirator Sergeant Jenkins for approval and to the time clerk, who entered them into the e-time computer program for processing, which provided the software and services for the payroll processing. To provide these services, ADP operated a mainframe system with servers located in Sioux Falls, South Dakota. South Dakota is not the same place as Baltimore. Yep. The evidence amply demonstrates that the defendants and their co-conspirators submitted fraudulent overtime slips by causing them to be transmitted. While the defendants do not appear to challenge the conclusion, they argue the record contains insufficient evidence from which a jury could have concluded the wire transmissions and the interstate nexus were foreseeable to them or any co-conspirator. As discussed, the fact that the wire transmissions were interstate commerce need not have been foreseeable to a defendant as long as we conclude the interstate commerce aspect is jurisdictional. So as to that particular aspect of the law, that is not a substantive aspect of the law. It's a jurisdictional aspect of the law. So the fact that you didn't know about it is ultimately irrelevant. They don't have to prove it because it's not substantive. It's jurisdictional. It just, did it happen? If it did, well, sucks to be you. Oh well. Don't break the law. Under the appropriate standards for finding foreseeability, of course, the question is more accurately posed as whether the wire transmission could reasonably be foreseen. We conclude the jury's finding that the wire transmissions were reasonably foreseeable is sufficient by the evidence taken as a whole and the light most favorable to the government. Works for me. Jury said it was foreseeable. They convicted. Great. Go to jail. Thanks. Considering all the evidence together and taking it in the light most favorable to the government, I wish to pause here to note that it's taken in the light most favorable to the government because the government has won. If we were below, they take things in the light most favorable to the defendant. So if this was still at the trial stage, you do it most favorable to the government, or most favorable to the defendant. But they're convicted. So it's most favorable to the government. Strictly speaking, it should be worded as most favorable to the verdict, but that's one and the same thing in this context. They won. That's the status quo. We're interpreting it in that light. The jury reached a conclusion, so we're interpreting it based on could they have reached this conclusion in the light most favorable to the jury. They rendered this verdict. So it must be correct unless it's not. So can you prove it's not? No? Okay, well, thank you for playing. We conclude the record contains sufficient evidence to support the jury finding we affirm. Taylor and Hurls challenged their conviction on count 2 by challenging the sufficiency of the evidence as to the underlying racketeering act, which must number at least 2 to establish the pattern of racketeering activity. In attacking the predicate racketeering acts on which their convictions rest, the defendant contend that all the wire racketeering acts should fail because of the government's failure to prove foreseeability. But we addressed that above. Go away. Short, sweet, to the point. Great, thanks. Both Taylor and Herschel challenged their conviction for the Hobbs Act robbery. I'm going to read this in full, but long story short, Hobbs Act robbery is just robbery that occurs in interstate commerce. So it's nothing special. It's just robbery that occurs in interstate commerce to give the federal government jurisdiction. But I will read the statute. The Hobbs Act penalizes a person who in any way or degree obstructs, delays, or affects commerce or the movement of commerce by robbery or extortion, or commits or threatens physical violence on any person or property in furtherance of a plan or purpose to do so in violation of the section. Commerce is defined as interstate in nature, while robbery is defined as the unlawful taking or obtaining of personal property from the person of another against his will by means of actual or threatened force or violence or fear of injury, immediate or future, to his person or property. Taylor Hobbs Act conviction on count 3 was predicated on the alleged robbery of Orsie Stevenson. On that date, the officers surrounded a minivan and took $6,500 from the $21,000 found in the van, and after that took $100,000 found in his residence. Taylor contends that no robbery occurred at the minivan because, according to him, the only items removed in the vehicle were property turned over to the police department's control unit. The jury doesn't believe you. The jury believes there were other things in the van other than what you turned over. The jury gets to determine the facts. Okay, well, that's what happened, so yeah. And he contends that no robbery occurred at his residence because nothing was taken from the person or property as another. The house is the property of another. Yeah, so go away. We conclude it's sufficient for the jury to infer that Taylor robbed Stevenson and his passenger, who took a portion of the cash. Yeah. Stevenson testified he was sitting in a van and conducting a transaction to sell Brown 1/2 kilogram of cocaine for $21,500. One of the officers who had been at the scene testified that it was Taylor who removed money from the bag, and Taylor later told him that the bag contained $15,000. It was undisputed that only $15,000 was turned into the police. Viewing this testimony in the light most favorable to the government, or most favorable to the verdict, and how I would phrase it, we conclude that it would be reasonable for the jury to find that there had originally been more than $15,000 and that they took money. Yeah, how much money was in the bag? That's a factual question. You say it's $15,000. The jury says it's $21,000. The jury believes the drug dealer over the police. I can't blame the jury. So that's how much money was in the bag. Yep, end of analysis. Herschel's Hobbs Act conviction was predicated on the alleged robbery of Hamilton. On that date, 3 officers entered into Hamilton's home without a warrant, searched and took approximately $70,000 and took $20,000 to divide amongst themselves. But the record does not support Herschel's claim that he was simply an innocent bystander. An innocent bystander to an ongoing home invasion. I'm not sure even conceptually that that's possible. To begin, he entered the house with the other officers without a warrant, surely knowing that they were not legally entitled to enter to conduct a search. One can only hope that the officer would know that, yes. Testimony also showed that Herschel became aware $70,000 was found, a portion of which he was later given and accepted. In addition, Ryan testified that after the officer found $20,000 in loose cash, I wish I had $20,000 in loose cash, I'm just saying. In his bedroom, Herschel was briefly alone with the money. Ram later realized that $3,000 of the $20,000 was tested missing. So it looks like the police officers might actually be stealing from each other, on top of stealing from the thing. They had $20,000 and separated it apart. And then one of the partners to the conspiracy count, there was only $17,000. So they're stealing from each other. They're stealing from their fellow co-conspirators. Excellent. He testified that Gondo believed Herschel took the missing cash, and so enforced Sergeant Jenkins, who nonetheless decided to leave it alone and split the remaining $17,000 before the 4 officers so as not to cause problems. Even if it was not sufficiently proved that Herschel stole the missing $3,000, he surely knew that $17,000 the officers took and divided amongst themselves was the product of the robbery. We conclude the jury could have drawn the inference that he was not a mere bystander. Again, I'm having a difficult time understanding how even theoretically he's an innocent bystander. He walked in with a group of people into the house who then divvied up money amongst themselves. That kind of makes you part of the conspiracy, man. You are part of an agreement in which a person took an overt act. Congratulations. The fact that you did nothing is irrelevant. And you did break into the home, so you did do something. So, yeah. The jurisdictional predicate of the Hobbs Act requires only the government prove a minimal effect on interstate commerce. In Taylor, we held the government may satisfy the Hobbs Act's jurisdictional requirement under 2 different theories, the pertinent one being here, showing a reasonable probability the defendant actions depleted the assets of an entity engaged in interstate commerce. The question is simply not whether one particular offense has a measurable impact upon interstate commerce, but whether the relevant class of acts has such an impact. So the philosophy of that goes back to Wickard v. Filburn, a case I'm not fond of, but at least here it came to use for good purposes. Interstate commerce is basically all the commerce. It's interstate commerce. Go to jail. Okay. While Hamilton did not quantify how much the business he conducted out of state, a rational jury could have concluded, since he testified to purchasing cars from 3 locations, his purchases from Mayhem, Pennsylvania constituted a substantial portion of his inventory. And we've recognized that a business that purchases a substantial portion of the inventory from out-of-state suppliers is engaged in interstate commerce for the purposes of the Hobbs Act. In addition, Hamilton specifically testified that some of the cash found in the bedroom came from selling cars, a portion of which came from Pennsylvania. We therefore conclude the evidence was sufficient to satisfy the Hobbs Act. The defense contend that the district court abused its discretion by denying their pretrial motion in limine to prohibit the government and its witnesses from using the term robbery during trial, and overruling their substantive objections to its use, especially in reference to the alleged predicate acts of the RICO count. They argue the government's use of the term robbery was prejudicial because to convict the defendant on the counts, they had to find the robbery. Wow, the government used the term robbery because that's what they're alleging. Robbery, that's the charge. So they say this is robbery because that's what they're trying to prove. So, yeah, they use the term robbery because that's the allegation. Robbery. Right. That's exactly what we're talking about. What's your problem exactly? Yes, this is RICO. It is very RICO. The government argues the district court did not err in denying the defense motion in limine, and they use the term robbery only when necessary, particularly when a co-conspirator that testified that he pled guilty to the robbery. So yeah, if you have the co-conspirator on the stand and you're like, hey, has anything interesting happened in your life recently? And said, yes, I've recently pled guilty to robbery. That's not prejudicial. That's just a factual statement. So, okay. The record shows that Ward, one of the co-conspirators, testified he had pled guilty to committing robberies and also fraud in overtime. As he described his plea, the district court asked the jury not to draw conclusions about the guilt of the defendants based on guilty pleas of co-conspirators. Yeah, I pled guilty to fraud and robbery. That's a thing that happened. I'm testifying about stuff that happened as part of my co-conspiracy. I'm using the terms of art. It was robbery because that's what I pled guilty to. Right. Okay. When Herschel's counsel objected to the government's use of the term robbery during Raham's testimony, the court reminded the government to rephrase its questions when possible so as not to use the term. Fair enough, we want to mitigate it. We don't want to message it excessively, but if we're charging you with robbery, it's probably going to come up once or twice. Finally, at the close of the evidence, the court again reminded the jury to draw no conclusions or inferences about the kind of guilt of defendant from the fact a prosecution witness pled guilty to similar charges. Fair enough. Just because someone else is guilty doesn't mean this person is also guilty. That in and of itself shouldn't establish guilt. However, it's probably going to be like, I'm guilty of this and I co-conspired with them. Jury's going to be like, they're probably guilty of robbery too. So the fact you're guilty is kind of like, yeah. First, we agree with the government that the co-conspirators' use of the term robbery did not state an opinion about whether Taylor and Herschel had committed robbery, but rather expressly acknowledged their guilt. Each plead guilty to conspiracy in which robbery was a predicate act, and their description of the predicate acts as robbing was accurate description of their pleas. Police officers testifying truthfully and fully, and these police officers have an issue with the fact that their former police officer friends are testifying fully and truthfully. Wow, that's nice. More importantly, however, we find the district court's repeated instructions to the jury, telling them to draw no inferences about the defendant's guilt, substantially mitigated any potential confusion. To be sure, there were occasions during the trial where the government used the term robbery, unprompted by a co-conspirator of the term. Presumably, as the government was laying out the charge that they were going to allege or try to prove, and they might have to solicit it as part of a question. So, yeah, it probably came up other than out of a witness's mouth, yes. But we conclude those limited occasions accompanied by the court's repeated instructions did not affect the outcome of a trial. Again, I'd like to wonder how many times, in how many cases that these police officers were directly involved in, how many times did these police officers testify against some other defendant and use a term like robbery from the stand as they were testifying? I'm just curious, how many times against how many defendants did they use the term robbery when they were testifying? But now all of a sudden that it's against them, they have a problem with it. The defendants also contend the district court abused its discretion in denying the motion to mistrial after the outbursts of the government's witness, Ronald Hamilton, the alleged victim of the Hobbs Act robbery in charge count 5. This outburst occurred when Taylor's counsel was cross-examining Hamilton as follows. Well, what are your mortgage? Check the record. What are your mortgage payments? Does it make a difference? What's this right here? Destroyed my whole effing family. Sorry, Your Honor. The court is all right. Witness, this destroyed my whole family. I'm in a divorce process right now because of this BS. This destroyed my whole effing family, man. You sit here asking me questions about the effing house. My effing wife stays in the effing Walmart every effing night until I come home. If you want to know about that, worry about that. That's what the effing matter is in here, man. Everyone's life is destroyed. My house don't have nothing to do with this. The problem is my wife is taking medication because of this. The court, sir. Man, I'm sorry, Your Honor. I'm sorry to the courts. But the fact of the matter is, my house doesn't have nothing to do with this. The fact of the matter is, they came in my house, destroyed my family. I'm in a divorce process because of this. Because of this has put so much financial pressure on my family. Kids, man, are scared to go in the house because of this. So it is a little unclear to me why the mortgage value of the home of the victim is relevant or why this has ruined his family. But I could try to make some speculations. One of the reasons that it might be relevant is because the size of the mortgage would go to like how valuable the house is. It's probably one of many questions that the prosecutor asked. Like how many bedrooms does your have? What's the square footage of the house? How big is your yard? What is the mortgage of it? These are all basically the same question, but they're all meant to elucidate a different answer, which is like, how big is your house? So it kind of goes to like why they targeted the house. Maybe they targeted the house because it's big and fancy and rich and therefore would have money. Maybe there's something about the house that would cause them to target this as the armed robbers they were. So maybe it is that this is a piece of evidence to go to the value of the home as part of, they targeted this house because of the nature of the home to show why it was interesting. Now, why it's ruining his family, I could only begin to speculate. I would speculate that it's because he had $70,000 of cash in his house and perhaps his wife didn't know about the $70,000 of cash in his house. So perhaps there is some marital discord about the random $70,000. Dear, why did you have $70,000 of cash in the house? Why is this a thing? So this is suspect on its own right. There might be some criminal or other misdeed there, but yeah, so I think that's probably what's going on. The government is soliciting the information to figure out how big the house is as part of their predicate, and it's ruining his family because his wife did not expect $70,000 to be there. So unfortunate, but that's the way it goes sometimes. Herschel moved for a mistrial because of the outburst, and Taylor joined. While the district court denied the motion, it struck the testimony from the record, instructed the jury the outburst was not responsive. It's important to recognize that on a courtroom issue such as this, the district court is best positioned to assess whether a mistrial is warranted or whether other means address the issue adequately. Because a mistrial is such a dramatic step, we will disturb the district court's refusal to grant one only in extraordinary circumstances, such as when the evidence is admitted that would prejudice the defendants and there's overwhelming probability the jury would be unable to heed the cautionary instruction. In this case, Hamilton's outburst was indeed emotional and disrupting. He is obviously upset to have been robbed by rogue police officers, or potentially upset that the $70,000 in his house has come to his wife's attention. Indeed, when testifying about the robbery, Hamilton spoke mostly about the corrupt acts of Sergeant Jenkins and only occasionally referred to Herschel. And by all accounts, Taylor was not part of this particular encounter. Moreover, the co-conspirators testified unequivocally they had robbed the Hamiltons. Hamilton's outburst expressed his emotional reaction to the event, but he said nothing inflammatory about Taylor and Herschel's involvement. For instance, the jury, despite the outburst, made individual guilt determinations as evidenced by the fact that it did not convict the defendant on all counts. For these reasons, we conclude the district court did not abuse its discretion in denying the motion for a mistrial and opting instead to strike the testimony and give a curative instruction. And that is the typical outcome from that kind of thing. When something like this happens at trial, the typical outcome is motion to strike and curative instructions. The judge will give an instruction when they strike it, and they'll also give a separate instruction when they give the jury instructions later when they're going back to the room to remind them about things that were struck from the record. So yeah, that is a normal outcome. If we had a mistrial every time something like this happened, we never get anything done. So mistrials are, as you would expect, an unusual remedy. It says it's district court discretion. It's not abuse of discretion. There's a reasonable remedy here, so no problem. Makes sense to me. Finally, the defendants contend that the district court erred in denying their motion for the new trial, which they filed 3 months after the jury verdict, because of new evidence that was discovered that would allow them to impeach a government witness, Antonio Santofel. They argued the government knew at trial that Santofel was under investigation for drug trafficking, but failed to disclose that in violation of Brady. So Brady versus Maryland is a very famous case and basically stands for the proposition the government must give all the evidence that would tend to undo their case to the defense and practice all their evidence. So they saying, look, the government knew about this and didn't give it to us, so we couldn't impeach him on this. Okay, let's see what happens. The defendant learned 3 months after the jury verdict in this case that a grand jury had returned an indictment against Santifel, charging him with participation in 2 drug transactions in May 2018, which were alleged to be part of a greater conspiracy dating back to November 2017. In other words, while 2 drug transactions occurred after the verdict were returned, the conspiracy was alleged to have begun well before Santifel testified in this case. On this basis, the defendants conclude Santifel must have been under investigation at the time that they was testifying, a fact they could have used to impeach the testimony. The record shows that on February the 1st, before the February 12th verdict, a poll camera recorded Santifel in possession of a firearm. The officers of ATF, a law enforcement agency that was not involved in this prosecution, prepared a report dated February 8th that identified Santifel in the footage and noted his status as a convicted felon, prohibiting him from possessing a firearm. That report was given to the U.S. Attorney's Office on February the 13th, one day after the verdicts were returned here. So it wasn't known to the government at the time of the trial. It came in one day too late. Sucks to be you. Ha ha ha. What a difference a day makes. The district court found during the trial the U.S. prosecutor had no knowledge of the poll camera data or any other investigation into Santifel. The court did recognize that this information could have been useful to impeach Santifel, but it concluded the evidence was not material because it would have provided only a minimal additional impeachment. The court noted the evidence had been introduced at trial of at least 2 prior felony convictions, one for illegal possession of firearm and second for illegal possession of drugs. In light of the evidence, the court found no reasonable probability that additional evidence would have changed the outcome and denied the motion. Yeah, so even if the government had known it, they told you about the other convictions, so you already impeached him based on his prior felony convictions for drugs and firearms. So what does the fact he's presently under investigation really add to that mix? We already know his trustworthiness is suspect. So there's not a lot more to be gained from that. So it's like, first of all, we didn't know about it. If we did, it's harmless error, so go away. Yep, makes sense to me. The defendants now contend that evidence that Santifel was currently not merely a former drug dealer would have been extremely significant in cross-examining. Really? There's a substantial, extremely substantial difference between former drug dealer and current drug dealer? I'm not sure there's enough difference to my mind. Such evidence, they maintain, could have produced a different trial result. The district court decision in Brady establishes the prosecution's suppression of evidence favoring the accused violates due process. To demonstrate, the proponent must show the undisclosed evidence was favorable because it was exculpatory or it was impeaching, material to the defense, it must have been prejudicial, and the prosecution had material facts and disclosed him. So basically, for me, all 3 of these fail. Well, okay, two of them fail. It was impeaching, but it wouldn't have been prejudicial, and they didn't have the materials. So for me, 2 of these 3 criteria fail. On the first point, the defendants argue even though the defense argued that even though the specific prosecutors in this case did not have information, the district court should have imputed the knowledge. No. The Brady's command is not so broad as to reach the circumstances of this case. Here, the ATF officers investigating Santifel were not part of this case's investigative team, which were made up of FBI officers. The ATF officers were looking into an entirely separate case related to the straight cash cartel. I'm not sure if I hate the cartel more because they're a criminal enterprise or because they spell the word cash with a K. Imputing the knowledge to prosecutors in this case would require us to stretch Brady beyond its scope and would effectively impose a duty on prosecutors to learn any favorable evidence known by any governmental agency. Yeah, it's way too broad. Way too broad. The defendants also challenged the district court's ruling that new evidence was not material, but we find it hard to imagine how evidence that Santifel was under investigation would have been consequential to his credibility in the jury's eyes, given that he was impeached to 2 prior firearms convictions and prior drug convictions. Evidence of this investigation would have been only cumulative and then only slightly. The information that he was under investigation does not undermine our confidence in trial outcome. Yeah, it would have made no difference. It's not substantial. No one cares. He's already been convicted. You were already able to impeach him. This has nothing new. Go away. We therefore affirm. Finally, Taylor contends their 216-month sentences are substantially unreasonable due to their increased vulnerability as incarcerated police officers and other factors. You know, I find it a little hard to be sympathetic to the police that the 216 months is too much because they're police officers. That's almost the textbook definition of chutzpah. The textbook definition of chutzpah is take mercy on me. I'm a widower because I killed my wife. That's the textbook definition of chutzpah. This is pretty close. It's like, I'm a police officer and I shouldn't be sentenced much because I'm a police officer. You had an obligation not to break the law like everyone else, and more so because you're a public duty. So it's like, I have a hard time having any sympathy for you. And I would like to take note, the Court of Appeals earlier in the decision said 260 months is already on the low end. So they already showed you mercy. So no, go away. This is a particularly sad case. The community places a noble trust in police officers to define and enforce, in the first instance, the delicate line between the chaos of lawlessness and the order of the rule of law. And when police officers breach that trust and misuse their authority, as in here, a measure of despair infuses the community, tainting far more than similar crimes by others. As to that, I tend to agree. It is more harming to the community than similar crimes by others, yes. For that reason alone, I'd give them more time, but that's me. The officers' convictions, and particularly because they did it in their capacity as police officers, or like their fellow conspirators were also police officers. So, yeah, the officers' conviction and sentences in this case are just and necessary, and we can only hope for the renewed commitment to trust that we place in police officers who discharge their duties well. The judgment of the district court is affirmed. So that is the case of the United States of America versus Marcus Roosevelt Taylor and Daniel Thomas Herschel. In this case, we learned that police officers in the Baltimore Police Department were co-conspiring with each other to break into people's homes, rob them of money, rob them of drugs, and other similar related crimes. They pocketed money, and they apparently robbed each other in at least one instance, where they took money from each other during an ongoing raid of property. So that's just a nice touch. We learned the government charged with RICO. We learned that sometimes it is in fact RICO. This was upheld. And we learned that the corrupt organization in this case was the Baltimore City Police Department. So hopefully this will bring some renewed confidence to the Baltimore City Police Department, but I know a lot about the Baltimore Police Department, and personally this doesn't make me feel too much better about the Baltimore Police Department. They've got issues. So yeah, it doesn't bring me that much confidence in the Baltimore Police Department, but at least it brings me some confidence that people who do bad things may be held to account. So if we're lucky, future police officers in Baltimore and elsewhere will be similarly held to account for their misdeeds. The rule of law should impact us all. Police officers are not above the law. They don't get special privilege. So that is the end of this case.